May it please the Court, Rachel Pickering, 3rd Judicial District Public Defender. Chief Justice Nuss, if you could please reserve 2 minutes rebuttal time.
2 minutes is granted.
Thank you. Just to give some facts of this case for the audience in case they didn't read it, I'm just going to address the handout that was presented. Early Saturday afternoon of August of 2008, there's a shooting that occurs, several shootings. Shots are fired. At the end, we have Lafayette Morris dead as he tries to crawl from his car to his mother's house. Mr. Darren Knox was convicted of first-degree murder for that shooting, and the witnesses to the shooting saw Mr. Morris, said that Mr. Morris, the victim, was shot by a person dressed in a black shirt and khaki pants. Another witness who was down the block saw the shooter in black pants and black shirt, and he did know Mr. Knox from the area. A week later, the gun that was allegedly used to shoot Mr. Morris was found in Mr. Knox's, in a car where Mr. Knox was a passenger. So there's several issues raised, and I'd like to start with the self-defense instruction, which was actually issue number 4 in my brief. With that, I'd like to move to the second instruction request on the second-degree murder, and if we have time, discuss cumulative error and prosecutorial misconduct. So, we've set the stage now for the shooting that occurs in August of just here in Kansas City, Kansas. So, for the instruction for self-defense, this was a favorable standard review for us. The instruction was requested by defense counsel at jury instructions. The defense counsel said, "Your Honor, we're going to request self-defense like we did last time." So, this is a favorable standard review, and this has to, we view the evidence in light most favorable to Mr. Knox. So from that, we go through the Plummer analysis step of reviewability, which we've done, whether there's unlimited review to determine the instruction was legally appropriate. So, KSA 213211 establishes the right to use deadly force in self-defense. Basically, from this statute, there are 2 prongs. First, a subjective intent, that Mr. Knox sincerely and honestly believed that it was necessary to defend himself or others. So in other words, the argument would be, while the shooting was going on between Mr. Knox and Mr. Morris, he had to defend himself. The second prong is an objective standard and requires a showing that a reasonable person in Mr. Knox's circumstances would have perceived the use of deadly force in self-defense as necessary. So, to qualify for this instruction on self-defense, this court asked,
was there any evidence about the circumstances surrounding the shooting, direct evidence at all?
No.
What occurred?
No. In terms of who was the direct evidence as to the beginning of the shooting, how it began?
Any evidence at all about the shooting other than from witnesses about what occurred?
Outside of the witnesses, we do have ballistics.
I mean, your client says he wasn't there.
Right.
Correct?
Right.
So it's, what evidence do you have that he was threatened by the deceit?
Okay. In this case, to support a theory of self-defense, you have evidence of an immediate threat.
And what is that? And
that is when the witness from the second-story floor across the catty corner across from the shooting, Crystal Fears, testified that Mr. Morris was shooting as well. So we have a shooting going on between Mr. Knox, although he says he wasn't there, the second defense is it was in self-defense or no premeditation.
Is there any evidence that he shot initially or even threatened to shoot initially?
No, and that is, none of the witnesses can testify who shot first.
No evidence that either one of them shot first, and there were no bullet holes from inside the car out, were there?
Correct.
Okay.
Correct.
So we know the first shots that came into the car, not from Mr. Morris shooting.
We don't know that.
How do we not know that?
We don't know.
There was blood in the car as well, right?
Right.
So we know he was shot in the car.
Yes.
By bullets that penetrated from the outside into the car.
Right, but he could have shot first. We don't have we don't have, there wasn't evidence to show that he did not shoot first. There was evidence that he was hit, certainly, inside the car.
Well, and
How did he-
wasn't there a rifle found inside the car?
There was a rifle found inside the car.
No evidence of it being shot, but it was in there.
Well, the jury never heard that, but yes, there was a rifle being inside the car, which would support the argument that he was well armed. Okay, that never came in, and that's a motion in limine issue, raised, issue 3. But I want to talk about the defendant must reasonably believe that his use of deadly force was necessary. So, Justice Rosen, your question, what is direct evidence? We don't know, and Ms. Blunting says that in her testimony at trial, who fired first. We have Mr. Morris, we have
Well,
testimony
what's
that
the
Mr.
evidence that he fired at all, other than that?
The evidence
She
is
said
from.
she heard gunshots, looked like it. We have evidence of a rifle being in the car but not fired. What's the evidence that he shot?
The evidence is from Crystal Fear's police
That's
statement.
it. That's it. Is
Well,
that the
she-
only evidence? That she believed that there was shots being fired?
No, there was a police statement that Crystal Fears made to the police, which she was cross-examined with at the second trial, that said she saw the victim, Mr. Morris, with a semi-automatic, brown with striping.
That was never,
Shooting
that was
shooting.
never found.
That was
Right.
never found.
I want to return to your statement about, that's it, though, on him firing. Is that one statement from her, right?
Well, we have, well, I want to talk about imminent danger. Him firing, her statement, the fact that there is a gun in his car also. We don't know how the skirmish began. And the district court statement.
There's no forensics, though, to
Correct.
support that he ever fired anything. No forensics that the victim ever fired a weapon.
The burden is
This
on the
goes-
state. The burden is on the state,
But
so
I'm
no.
just getting, but you have to support a self-defense instruction.
Correct.
There has to be evidence from somewhere to support
Yes.
both subjective belief on the part of the defendant and that an objectively reasonable person would have felt threatened enough to justify deadly force.
Right,
Okay,
but
so
I
I want to
don't-
return to what the list is of evidence to support that. And you suggest that the statement from Ms. Fears, I believe was her name,
Correct.
which she said she didn't remember him shooting at the second trial, but they impeached her with her previous testimony or previous statement. So that's evidence.
Yes.
Otherwise, we've really got an absence of evidence, don't we? Because there's no, the car was, the windows were rolled up. If he had shot from that car, there'd be a bullet hole going from the interior of the car to the exterior of the car. Isn't that correct?
Well, the door could have opened.
Okay.
We don't know the
They
beginning
were
of the
shooting into
skirmish.
the passenger side, weren't they?
Yes, but the door could have opened. He could have started it first. We don't know what happened at the beginning. That lack of evidence as to how it started is also credence for the self-defense instruction, as well as the second-degree murder. We don't know if he opened up the door. Remember, they hear music blaring.
Right.
Whenever he drives in, they hear music blaring. How could he have not? Wouldn't that suggest he could have opened his door? And he has a rifle.
Let's move over to where is the evidence that your client honestly believed that there was an imminent threat when the defense was he isn't there?
Right, well, you could have two theories of defense. The state's burden is to prove Mr. Knox committed this beyond a reasonable doubt. Mr. Knox does not have to limit himself to one defense.
There has to be evidence, though, that Mr. Knox believed he was in imminent danger.
Right.
And where is that evidence?
That evidence is evidence that Mr. Morris was shooting at him. The evidence is that the other person with Mr. Knox was seen running away.
Doesn't there have to be some evidence about what Mr. Knox believed?
No, he does not.
Or saw, or something, and of course his defense is he wasn't there.
Yes, but you also have testimony from the state's witnesses putting Mr. Knox there, putting Mr. Morris shooting. You have, in this state, juries are allowed to infer state of mind. Mr. Knox does not have to go and testify. He does not have to waive his Fifth Amendment rights to show that he reasonably believed this. We can get this from the testimony of the
And
witness.
that would be true if he didn't testify, but when he says he's not there, how can he provide the evidence that he was, felt the threat or imminent kind of danger when he says he wasn't there? I mean, yes, you can infer that from evidence when maybe the evidence is silent, or maybe he says he was there, but how do you get there when he says, how do you get there with his subjective or objective belief that he was in danger when he says, I wasn't even there?
Because he has multiple theories of defense. I wasn't there, yes, you weren't there.
I
However,
wasn't there, but if I was there, is that his defense?
that could be in it. That
Okay.
could have been it.
If I
Again,
wasn't
the-
there, I was really scared.
I'm sorry?
If I wasn't there, I could still be really scared, you know, or if I was there, I was really scared, but I wasn't.
Well, think about it, Justice Biles. Look how weak the state's evidence was that Mr. Knox was there. We have two witnesses with credibility issues.
But how
with
do you
contri-
have
conflicting-
2 prongs? Counselor, how do you have 2 prongs, one subjective and one objective, if you're asking us to use the objective circumstances of objective to find subjective? I mean, there's 2 prongs for a reason. You have to prove both that the defendant believed and that there was evidence from which a reasonable person could find that there was a need. What you're asking us to do is conflate those into one and say the objective evidence is enough to show that he must have been scared or must have been in fear.
What I believe what you're asking me to do is to concede that Mr. Knox must testify in order to meet that first prong. And his Fifth Amendment rights do not have to be waived in order for this court to find subjective finding.
Do you have,
How
a-
can you
do you have a
do-
case where we've said that? Do you have a case, because it seems to me that
I
our
did
cases-
research on this. I did research on this.
Okay.
And I haven't found a case that said
Yeah.
that a person's, in order to raise the self-defense, that he must testify.
I understand your
Thank you.
Fifth Amendment argument, but I just think as a practical matter, we've never said that a self-defense instruction was merited unless someone has testified about their subjective intent.
Right, but my point is I don't want to get to that point. We're here, a subjective intent, reasonably and sincerely,
Subjective
How does
belief,
he-
I should say.
I'm sorry?
The person must have held a subjective, honest belief that deadly force was necessary.
Right,
And I think what's troubling us, perhaps I should just speak for myself, is there's no testimony from the defendant that says, yes, that was my subjective, honest belief. There's no testimony from anybody else who said, the defendant told me this. There's nothing in writing where the defendant said that. It's just you're asking us to look at the facts of this case and conclude that he must have had a subjective, honest belief that deadly force is necessary. And the stumbling block is that's subjective.
right, but subjective, I think this subjective could be still, again, I go with his testimony is not required. He does not have to,
So how do we get there? How do we get that he was in fear from the evidence?
the evidence would be that when the.
I know what you're saying the evidence is, but how do we get from, there's the evidence, those are the circumstances, how do we get to a subjective fear without saying an ordinary person in those circumstances would have experienced that, and then I'm back to where I was before. This guy might be fearless and nothing scares him. And what may scare me may not scare him. And that's why we have 2 prongs. And you're asking us to say what a normal, ordinary person would feel we have to ascribe to this defendant, even though there's absolutely no evidence that this defendant experienced that situation.
Well, the evidence I would say would be his actions. We infer state of mind. We
The
have
fact that
some,
he was shooting back, then.
that he's shooting back, that he's shooting back. His actions would do it. I don't know how much time I have left.
Actually, you're over time, but
As
we've
normal,
been,
as
we've been
predicted.
asking a lot of questions. Would you like 30 seconds to wrap up?
Yes, I want to get to cumulative error in 30 seconds.
Yes.
In 30 seconds, cumulative error. I believe this, and I'll try to do it, and I'll time myself. We have an unfair trial. We have a jury that was hung on the first trial. So what changed? The prosecutor's statements changed. That weighed against Mr. Knox. We have a motion in limines that should not have come, that should not have been granted about how the victim was armed. We have,
That wasn't true in the first trial?
that's true, it did happen the first trial.
Just give us the differences.
The
Wasn't he tried
difference
with a
was-
co-defendant the first time around?
The difference is the key witness's testimony, Crystal Fear's testimony, changed because she had the victim shooting back, and the difference is the prosecutor's closing arguments went overboard.
Wasn't there also a co-defendant in the first trial?
Yes, yes. I'm sure that is my 30 seconds, Your Honor. I will wait to address any other further questions on rebuttal. We ask this court to reverse and remand for new trial.
Well, I think we can still ask you questions and not save for rebuttal. Am I mistaken?
That's true, Your
All
Honor.
right. Any more questions of counsel? Thank you.
Thank you.
May it please the court, Jennifer Myers, Special Prosecutor for the Wyandotte County District Attorney's Office, on behalf of the appellee. I think that we should first start off with what were the facts that were presented in this trial. The facts were that Lafayette Morris arrived at a relative's house and he pulled into the driveway. So his vehicle was facing that residence. He was in the driver's seat, he was the only occupant, and his loud music was blaring. And this was important because the witnesses testified they knew when Lafayette was home because his music was blaring. So they heard Lafayette pull up right before this happened because they heard his music. And then they hear gunshots. And they look out the window and they see 3 subjects running north. And a few of the witnesses testified that they saw a burnt orange avalanche at the top of the street to the north, and also a white truck. This was also corroborated by Darius Freeman, who didn't actually see the shooting, but was a distance away and saw the burnt orange avalanche and the white truck driving off, and that was in the same direction. So that's the evidence. The physical evidence at the scene was that there were 2 guns used, a 9mm and a .40. This is important because the witnesses across the street saw 2 subjects shooting. And the evidence of where the shell casings went up from Lafayette Morris's vehicle up north to where the getaway car was. So those vehicles up the street were getaway cars. Mind you, this happened at 1 o'clock in the afternoon, I believe on a Sunday afternoon. There was no evidence of argument, no evidence of a party going on outside. This was 1 o'clock. Nothing was going on. This was a premeditated murder. They parked up the street in the 2 vehicles. 3 of the subjects exit the vehicle, came down to Lafayette's vehicle. They shot from the passenger side. Lafayette was probably not even aware they were shooting because all of the bullets, all of the physical evidence indicate that they were shooting from the passenger side of the vehicle.
But wasn't what called the attention to the people that were viewing the crime, the noise, I mean, so we were really dealing with coming into perhaps a scene partway through it.
We do, because there's no evidence of what started, you're correct, of what started it, but the fact is that they were parked up the street. They ran down the street. So that evidence of self-defense, why were they there? Why were they running by? We can't imagine that they were just out for a jog in that area and Lafayette just started shooting. They parked up the street because it was a premeditated murder. And they exited, they came down to where Lafayette was, they shot from the passenger side, catching Mr. Morris off guard, presumably, and then they ran back up north to where those vehicles were parked, and the vehicles sped away. This was a premeditated drive-by shooting. So the fact that Crystal Fears at one point somewhere in her testimony said that he was holding a handgun, there was no evidence that it was fired. We have 2 people across the street saying they saw 2 shooters, and those were the ones that were fled. There was a .40 and a .9 used because we have shell casings. So where's the evidence that that handgun was ever used? Where was the handgun? Crystal said that she came immediately after the shooting. Presumably, I don't know how long it took the police to get there, but presumably it was a quick response, and there is no evidence of a gun.
Let me
No
just
hand-
back you up. Oh, excuse me.
I was going to say, no handgun was recovered,
No.
correct?
No. And no, when the police arrived, there was no handgun on the scene. And Mr. Morris, we know that he was shot in the vehicle because the blood was in the vehicle, and he tried to exit. And Crystal said that as he was trying to exit, that's when she saw the gun. But there is no evidence that he fired.
That was just what I was going to ask you. My memory of the evidence was that she saw that gun firing, but you're saying she didn't see him firing, she just saw him holding it.
She said that in part of the testimony that I read, I don't have access to the whole record, but it said she saw him with the gun as he was laying on the ground.
Okay.
But I believe maybe one of her prior statements was that she saw him firing, but she came off of that in the second trial, and she said, no, I don't remember him seeing that. So-
Why did she come off it in the second trial? That's how you put it, came off. Why did the testimony change?
She changed, and this was a very thorough cross-examination. And unfortunately, when you read the record, you can't really see what was going on in her demeanor and her attitude. This was a frustrated witness who was getting, as I said in closing, beat down by defense counsel. And I don't know, I can't explain why it changed.
And what was the time period between the first and second trial? Do you know?
It was pretty quick, within 2 months, I believe.
Okay.
Actually, I have it. I'm sorry, I don't, but it was pretty quick. It was a quick
Within-
turnaround.
okay, thank you.
Yes.
But of course, the second jury heard the fact of her testimony in the first trial, that she
Yes.
thought there were shots.
Yes. And as to the rifle that was in the vehicle, one of the issues is the motion in limine was improper because it was excluded. There was no evidence that a rifle was used. No physical evidence that the rifle was used, and Ms. Fears never testified that that rifle was ever in Mr. Morris's hand. So I find it hard pressed for the defendant to have known that the rifle was even in the vehicle based on the evidence.
Counsel, this was an instruction requested by the defendant, correct?
Yes.
Could you mind telling the audience and also me what our standard of review is to determine whether we find that this is reversible error?
It would be, I believe it would be a harmless error test.
And what are we looking for to determine if there was error?
You would have to find, well, first of all, the defendant would have to prove that he reasonably believed his use of deadly force was necessary to prevent imminent death or serious injury. And then if you find that this is a constitutional error, you'd have to find beyond a reasonable doubt that the outcome would have been different had the jury been given this instruction.
Well, Counselor, I think recently we clarified when we have an instruction issue that first we look at whether there's preservation, and
Okay.
here there is, because
Yes.
secondly, whether it's legally appropriate. Here it is legally appropriate. Would you not agree that, and next we determine if it's factually appropriate, and you're arguing that it's not factually appropriate because the facts wouldn't support it. And then we determine, if we disagreed, then the next step would be whether it's harmless error, whether you can convince us that it didn't, the error didn't change the outcome.
Yes.
Would you agree that's the steps we go through?
I agree, those are the steps. I do believe that it was preserved for appeal. Was there legally appropriate? I don't know. I believe in order to get a self-defense instruction, there must be some evidence that the defendant was put in fear that he was going to be killed. And I don't believe there was any evidence in this case that supported that. This was a premeditated.
Counsel, help me with that. How, by his actions as the appellant's counsel, doesn't that show a subjective fear that if indeed he was the person shooting, that his actions indicate a subjective fear?
I respectfully disagree. No, they parked up the street. They ambushed him. 3 of them ambushed him.
Well, we're not talking about the amount of evidence. We're talking about whether or not there's any evidence, aren't we, for an instruction purpose?
What?
I think our standard is whether a jury could reasonably acquit on the basis of self-defense. And it sounds like your position is this evidence from a witness that she saw a handgun in his hand and he was shooting it would be insufficient for a jury to say, yes, we find that he engaged in self-defense, therefore he is acquitted on the charge.
Yes,
Is that
I
right?
agree with you. And in fact, the jury did hear that evidence. They weren't given the the self-defense instruction, but they heard the evidence that Crystal in a prior occasion had said he had a gun, and they didn't buy it. They didn't, they must not have believed that point. So I don't believe the evidence is sufficient that it would have rendered a different verdict.
Counsel, moving over to the prosecutorial misconduct argument, what's your explanation for, during closing arguments, when you said that your opponent, your defense counsel, his job is to make them look like liars? That's his job, and that's what he's trying to do. And the first thing we have to decide is whether that's in the wide scope of what prosecutors get to do in closing arguments. And so I want to hear your defense of that.
I believe that it is within the wide latitude that prosecutors get. My argument was, I believe this was in the rebuttal portion of my closing, and discussing the defense attorney's attack of my witness's credibility, of the state's witness's credibility. So I believe that a defense attorney's job is to attack the credibility of a witness, to make them look like they are not telling the truth. Should I have said, make them look like liars? I probably could have said it in a different way, but I believe that's the job of the defense attorney, and he effectively did it in this job. Every detail was attacked as far as these witnesses' credibility, their motive for testifying. And so I believe when you attack somebody's credibility and you are arguing you are not telling the truth because you have a motive to lie, I believe that's asking to find that they're untruthful, or in other words, being a liar.
So, I didn't mean to cut you off. So it's okay to say Freeman was on the stand telling you the truth?
I did say that, and I believe the difference in the situation where I did say that, if you read it in context, I said he was brutally honest on the stand. But right before I said that, I was talking about his motivation to testify. My quote was, his testimony that there's no promise he's going to get leniency for his testimony. He's hoping the government will consider that, but there's no promise. He doesn't know what benefit he's going to get. He was brutally honest. And just for the members who are watching, this was a person who was in custody on federal charges. And the evidence that I believe both parties were aware of was that he received no plea bargain for his testimony in this case. The evidence was he sure was hoping for a benefit, but there was no promise. And so I don't think this was a disputed element in the case.
How do we know, what evidence was there that he was brutally honest?
Well, he said, I was talking about.
No, I mean, I know what he said, but how do we know that that's the absolute truth, that he was being brutally honest?
I believe that both the defense and the state had verification that he did not receive a plea agreement in this case. The government had not offered him a plea.
So you're saying when you said he was brutally honest, that referred only to the fact that he didn't get a plea?
To his motivation for testifying is how it's read in context. I said he was brutally honest based on the fact that he wasn't getting a plea agreement out of this. He was simply hoping for a good benefit in his case. And then I said, he went on the stand. He was on the stand telling you the truth. Once again, that was going to not to what happened, but to his motivation for testifying. And if you recall the motivation for him testifying, the defense was asking, why didn't you come forward? If you knew who did this, why didn't you come forward? And he said, look, I didn't want the police involved because I wanted to kill him myself. I wanted street justice. And that's what the defense, essentially their whole argument was. Look, he's not telling the truth. This is his enemy. He just wants to nail him. And so these weren't really arguments or elements of the case that were in dispute. And then I think I further went on. If you go to the ill will prong, or was it flagrant?
But wasn't his testimony in dispute? I mean, he's the one that places the defendant at the scene.
Yes.
That was the crux of the case. And doesn't your statement envelop all of that?
I believe when I said it, I was intending just to go to his motivation for testifying. And I think I followed that up by saying, I went on to say, you know, does he have credibility issues? Yes, he has credibility issues. And I asked the jury, I said, judge his credibility like you would any other witness. So this wasn't ill will. This was just look at his testimony. Look at the reasons why he would do this and judge him like you would any other witness. And
So judge his credibility even though I, the prosecutor, am telling you that he's telling you the truth.
as to his plea agreement. As to the plea agreement that defense counsel there was no question there of the plea agreement. And that's when I said it. And I will give you this, you know, defense counsel in his closing argument said, if you're being honest about it, why say you don't remember when talking about Crystal Fears? He went on to say, she wasn't truthful about whether she knew Knox or not. You can't both be true. And then he also went on to say, Brittany was honest and said they were too far away. So, you know, I can't say, you know, I said it, but at this case, this was back in 2009. We didn't have this wealth of opinions that we do right now of what the latitude is for a prosecutor. And you have both counsels in 2009 saying, look at this witness is being honest. Not that that's right, but that's how it played out in this case. So defense counsel said almost the exact same thing. So I would argue as far as the prosecutorial misconduct, there was no ill will. It was a witness who got up and said, I didn't come forward because I wanted to kill him myself. I think a jury can look at that, and they don't need me vouching for his credibility. They can say, you know, yeah, they're enemies. It's probably rational that he would feel that way.
Assume with me that we would say that you were outside the wide latitude, and we get to the point of looking at harmlessness. Could you respond to your opponent's argument that really the only thing different in this case was the prosecutor's statements about credibility and the Fears' change of her testimony and the lack of a defendant? And in other words, tell me why any statements about his credibility that you might have made were harmless.
I don't believe that those were the only differences in the case. The first case was with Matt Calhoun, who was also another co-defendant. So you had two co-defendants, two defense attorneys. I think that anytime you've got two, it kind of jumbles a lot of issues. So after Mr. Calhoun pled after the first trial, I think narrowing it down to one defendant and the facts that point specifically to Mr. Knox, I think are just stronger. And so while Crystal Fears may have changed her story a little bit, no one, she never came off the fact that it was Darren Knox who did it. Her mother, who testified, never came off the fact that it was Darren Knox who did it. They both picked him out of photo lineups. You have Darius Freeman's testimony, who said he saw him. You also have the jail phone calls, where afterwards, Darius Freeman gets a phone call from somebody in the jail named Ron, said, I got your boy Lafayette, you're next. There was evidence presented by jail administration that Ron is the name that Darren Knox goes by. So I believe there was also the Orange Avalanche that was up the street. What was the connection there? Well, Darius Freeman knew that belonged to Christopher Holliday. Christopher Holliday's vehicle was pulled over about a week later, and the Orange Avalanche had been painted. And then finally, there's the evidence that Darren Knox, 1 week later, gets pulled over on a traffic stop, and he has the murder weapon. So I believe that evidence is very strong. I don't believe the fact that I vouched for the witness's credibility about his motivation to testify. I never said, look, he's telling you the truth, Darren Knox did this.
Just for clarification, though, that he didn't have the weapon and it was in the location near him in the vehicle.
I believe it was under his seat in the vehicle.
Under his seat, right, okay.
With 3 other occupants?
Yes, and I believe he was charged with the weapon.
Possession of the weapon?
Yes.
I'd like you to address the issue on the second degree, or excuse me, the intentional murder. Yeah, second degree intentional. No one's talked about it, but I just want to hear your side on that one.
I believe there is the 4-step analysis, and the first one, was it preserved? He did not ask for it, and I think this is so important. This was charged as premeditated first-degree murder. His theory of defense was, I didn't do it, I wasn't there. So it's not beneficial for him to ask for second-degree intentional murder, because that gives the jury kind of an out. Sometimes juries negotiate the charges. And so if you don't give him that negotiation, he was hoping for a not guilty or a hung like they did in the first trial.
Regardless of whether he asked for it, though, that just controls our makes it our clear error standard rather than the other.
Okay, the
So-
sufficiency of the evidence, I still agree. I still think the facts are very strong that this was a premeditated murder. They parked up the street. They ambushed him with no provocation. Multiple guns were used. And then after they shot him, they ran back up to the getaway vehicle, got back in, and left the scene. So I believe that the evidence did not support the theory that this was anything other than a premeditated drive-by shooting. What else are you trying to do when you ambush somebody and start shooting multiple times while he's sitting inside his vehicle? That is a premeditated murder, and I don't see it anything other than premeditated.
I see you're out of time, counsel. Would you like 30 seconds to wrap up, or do you think you've made your points?
Okay, and just to address your final element is, did it affect the outcome of the trial, not giving it? And I do not believe that the failure to give the second-degree instruction would have affected it. They first would have been instructed on premeditated murder, which they were in this case. The jury considered the facts, considered the credibility issues, considered everything that was presented, the demeanor of the witness, considered all of that, looked at premeditated murder, and found beyond a reasonable doubt that Darren Knox, with premeditation, killed Mr. Morris. And so I believe that any of these errors would not have affected the outcome of the trial.
Thank you.
Thank you.
Any more questions? Thank you, counsel.
Thank you.
I have 5 points to make, actually 6. Thank you, Justice Nuss, for asking what was the standard review in the self-defense and the light most favorable. That should help us in looking at the evidence for Mr. Knox. 2, this prosecutor said that Crystal Fears came off of it. Her testimony in the second trial is substantially different from the first. In the second trial, she does acknowledge volume 18, page 122, that Mr. Morris was shooting. She was asked, were you asked this question, did you give an answer? Did you see anything in Lafayette's hand as he was running? Answer, this is the defense attorney reading back her first trial testimony. Answer, yeah, did I read that correctly? She says yes. And were you asked a question, quote, and what did you say? And did you give this answer? A gun. Yes. Did you say, and then later on he says, and you also stated you saw him firing that gun, correct? Him being Mr. Morris firing the gun. Yeah. I'm sorry? Yeah, that's what it says. So you do have her testimony that she saw Mr. Morris with a gun and shooting it. We also, I want to correct the record, the mother, Miss Bunting, does not identify Mr. Knox as the shooter. That is in the record, that she could not identify him at the hearing, nor could she identify him on cross.
One of the other ones from across the street did, though. Fears and then one more, right?
No,
There were 2 out of 3 who ID'd him?
I believe only one of the 3. If I'm wrong, my apologies. I know the sister couldn't see anything, and the mother, I want to make sure,
I thought there was
on
a
cross.
failure to ID a black and white and then able to ID a color or something like
yeah,
that.
she couldn't identify him to the police, and that's volume 19, page 312. Okay, so that changes things in terms of whether there was a gun and whether the mother did, whether there was a second ID outside of Mr. Freeman and Ms. Fears.
Counsel, you're out of time. But
I'm sorry.
Since we're feeling generous today, I'll give you 1 more minute to establish whatever other points you want to.
Yes, the state says they didn't buy it in terms of the jury. That goes to the, in terms of the jury with the second-degree murder, reckless, but maybe they would have bought it if they had been given this second-degree murder intentional instruction. And so that, I just wanted to make that point. The prosecutorial misconduct, I want to let this court know there's 3 cases that stand out of what is permissible with respect to a defendant's prosecutor's statements on truth and calling people liars. 2000 was Papps, 2004 was Tosh, and 2008 is Morse. These are all two Supreme Court arguments. Morris is Court of Appeals, in that prosecutors are being advised they are not to inflame the jury by saying who is the truth teller and who is not. Thank you.
Any more questions? Thank you, counsel. And thank you both for your arguments this morning. The court will take this matter under advisement.